They're not, it wasn't convicted. Everyone. Inside from the system. Yeah. You treat that a lot. Thank you. Yeah. Yeah. So.
This is one I looked at before, I never picked up, and it was there, so now when I was looking at it, it showed how much cheaper it is. Yeah, as I was looking at it. Well, yeah. And of course, right by the accident, watching. I saw this once again, I hope I pulled it.
Oh, yeah, I like that.
Frenchie's members.
Yeah, that's really cool. I like that.
But it has to feel. We'll just stop. So I feel good. There you go. You know, makes sense. Yeah. And trying to buy, so. I think you're, but that's a long time. So.
Yeah.
With my, those costs and stuff, so.
Yeah.
I think that will be.
Where's
Stay on. Right off the University of New York, this was a long man and a big county. South.
All rise. The Honorable Court of Appeals for the 7th District of Texas is now in session. Be seated. Good morning. We have on our docket this morning a motion for rehearing filed by the state. And are you ready?
I am wrong.
Okay. And Mr. Wilson, are you ready?
No, it's ready, Judge.
Ms. Lou, you'll have 20 minutes to present your argument. Mr. Wilson, you'll have 20, and then Ms. Lou, you'll have a 5-minute rebuttal. And I'm presuming that Mr. Rippey and Mr. Clark are not arguing today. Go ahead.
May it please the court. My name is Emily Johnson-Leo. I'm with the State Prosecuting Attorney's Office representing the state in this case from Randall County. I appreciate the opportunity to be able to come here to more fully explain our motion for hearing and hopefully to be able to answer any questions that the court has.
Well, can the state raise a new argument in a motion for rehearing? Essentially just changing horses in the middle of the race?
Well, I think the issue really is the same as it's always been. So the appellant raised an illegal sentence claim. And as part of that, the district attorney's office raised this argument about harm and whether or not 1242D, the general enhancement scheme, would provide a opportunity to make the error harmless. And this court addressed that issue, whether or not the indecency conviction could be used. Because of that issue that is in the court's current opinion, that's why the state prosecuting attorney came in to address that particular issue that is live in the Court of Appeals opinion.
You would agree, though, that the state's previous position was contrary to what the state's taking now, right?
Absolutely. So the state below did concede error. This court, like any court, would has the ability to look past a concession of error and decide for itself whether or not they feel that error occurred in the case and whether or not it warrants remand. And so that's the question that we have raised in the motion for hearing, is whether or not the court's opinion on that particular issue is correct. So there are sort of two legal issues, I think, that are at base in this case. One is the one that I briefed in the motion for rehearing, which deals with what the court addressed in the sort of no dual use of the indecency for the primary offense plus for enhancement. And then the other legal issue is the ex parte parrot issue, whether or not this is a case that merits sort of a harm extension, because ex parte parrot, as the court's opinion recognized, is a habeas case, and should that be extended here? Now, I don't think ultimately that issue is going to control, because even if this court maintains its position that the habeas posture is different than what we have here, when the case gets remanded to the trial court for that redoing of the punishment hearing, the issue of whether or not that indecency is going to be available or not is still there. So we still need guidance for the court, for the trial court. And so that issue, I think, is still alive.
Well, what the judgment does not identify the applicable degree of the offense. It's just listed as felony unassigned. So what was the degree of offense that the appellant was convicted of?
Well, it would have been a first degree ultimately, because that's the range that the trial judge, in finding a 25-year sentence, the trial judge and the parties would have understood that to be first degree felony range.
Well, there are multiple problems with the judgment. The statute for the offense is listed as 62.102C, which is the special
That's right.
enhancement statute. It lists felony unassigned, and the court found one enhancement true, and the only one alleged was that the defendant was convicted of failure to register. So I'm having trouble. Don't you have to allege that you're using the indecency with the child as an enhancement? And where was that done? Where was the defendant given notice?
That's why I think this case is not a great extension for ex parte parrot. Okay, because there is lots of due process concerns for the theory that the state is talking about on appeal, the theory that we're alleging. But if we had illegal sentence, the way that we gave notice, which was using the special enhancement, which is listed, the 62.102C, plus the third degree felony, which was alleged in the enhancement paragraph, those together, that was not a proper way of enhancing this case. And that's the theory under which the defendant had notice. So there are definitely due process concerns, which the court had concerned, hey, is this really an appropriate case to extend ex parte parrot? Because we don't, in a habeas context, you would be able to give that notice then, okay? And we don't have that here on a direct appeal. So I absolutely think the court's concerns are right on there.
Well, would that not be fundamental error?
Well, if there is improper enhancement, then that is trial error. Something that you would go back and retry punishment. Okay, but because it is not one of those issues in the U.S. Supreme Court does not preclude retrial for enhancement issues because it's not part of the offense, right? So there's not a double jeopardy concern. The state could allege a different theory of enhancement on retrial. So that's why we still need to resolve the issue of, is this no dual use rule still at play? So if I can then move on to that issue, because I think it warrants this court's attention. It's pretty complicated. And I'd like to be able to answer any of the court's concerns there. So, okay, moving then to this rule that we have from the Court of Criminal Appeals from beginning in the 1960s through Garcia and even up to McWilliams in the late 1980s and early 90s. So we have this rule that you can't use a prior as an essential element of the primary offense and for enhancement purposes. And this rule, when it's, especially in the later cases, when it's referred to, it seems like it might be a court-made doctrine, something that's sort of just as a fairness concern. But if you go back and trace its origins and see the original cases that the court is citing to, it makes it clear that it's really a question of statutory interpretation. Because you have two statutes that the legislature has passed that are at issue here. The general enhancement provision in Chapter 12, so it's 1242D, and the statute of the primary offense, which is failure to register. And is there an irreconcilable conflict between those two that would indicate the legislature's essentially signaling, hey, 1242, the general enhancement scheme is invalid or inapplicable here. We need a clear statement of that. Going back to the Court of Criminal Appeals original case law, so in Garcia, Ramirez, and Wisdom, those are the felon in possession cases. And the court is looking at the statutes for those and saying there is an irreconcilable conflict between the felon in possession punishment range, which always takes into account a felony conviction, and the enhancement scheme, which says if you have a felony conviction, that can enhance your sentence.
What about McWilliams? McWilliams talks about those. It involves an escape statute. You don't have to have a conviction to fall under the statute. You can be a pretrial detainee. And yet McWilliams applies the same Garcia Ramirez line of cases to say that you can't use it to both serve as the element of the offense and enhance.
So that's right. That's the case that should give this court pause. But it's a plurality decision. We had Judge Teague and two judges join that decision, and then 6 of them concur in the result. So it's not going to be controlling authority on this. Plus, if it's really a statutory interpretation question, then how the Court of Criminal Appeals interpreted the escape statute should not control how this court interprets the failure to register.
Well, agreed, but you've used that line of cases as an analogy, I guess, to say, okay, it's distinct from felon in possession cases because we're dealing with a failure to register. The Austin Court of Appeals certainly relied on Fitzgerald and McWilliams as an analogy when it reached its conclusion that this court reached in our initial opinion. And so I don't know that we can say, well, we're just going to ignore it completely. It certainly speaks to trying to resolve this issue. But the reason I bring it up is it seems to undermine part of your theory of the case, which is we don't have an irreconcilable conflict at least under the McWilliams line of cases. I understand your position that is plurality and we may have it for a different issue, but what's your response on that?
I mean, when you're dealing with an escape statute, seems similar to felon in possession. They may have just said, at least 3 judges on the Court of Criminal Appeals said these are analogous enough. And the other distinction between that offense and ours is that you're never going to have a conviction arising out of a mere pretrial detention. And so you're not going to have the situation like we have here, where the duty to register arises out of a deferred adjudication. And that person may later be convicted of that offense. So you have this availability of a separate theory, a separate distinct event giving rise to the use of the enhancements. I still think that McWilliams is not authority that this court has to follow. And I think especially because sort of factually there's that difference of being able to use the deferred adjudication in this case as the element that requires him to register. So that's for the primary offense, and the conviction that later occurs is available for use as enhancement. Ultimately, though, I'm seeing puzzled looks. So in 1999, he got the deferred adjudication for the indecency. And during that time, that is the point in time which he has to register for life. He, in fact, picked up additional failure to register offenses as a result of that just deferred adjudication. He was then adjudicated, I think, in maybe 2000, and that led to a conviction. But it makes sense that the legislature would want to treat differently someone who was merely on deferred and never was adjudicated versus the person who, like our defendant here, has a duty to register from a deferred, but that then turns into a conviction because he's not following the rules of probation. And for that to be available for enhancement, if indeed he does get adjudicated. And that the question of statutory interpretation turns on that sort of, do we have an absurd result? And I don't think you do. You have a situation where it makes perfect sense that the legislature would not want to treat those two people exactly the same. Someone who was on deferred and never messed up versus the person never messed up to get their probation revoked versus this defendant. And if you follow Ballard, the third court's decision, those two different people are going to be treated exactly the same. It makes it so that 1242D, this statute that the legislature has passed, it essentially invalidates that. And really, as a question of statutory interpretation, to be able to do that, you need a clear statement from the legislature. It could be something like we have for DWI. In 4909E, that section for enhancements says very clearly, you can use a prior DWI to raise it to DWI second or to felony DWI, or you can use it for enhancement purposes, but you can't use it for both. That is essentially the same question that we're dealing with here. Did the legislature envision that for failure to register, that offense, making it sometimes a third-degree felony when you had a conviction, that would invalidate 1242D? Did they envision that? And I don't think we have that clear statement here, because there are many situations when you do not have to have a felony conviction, and the legislature said it is still fitting that you have a third-degree felony punishment, that is an appropriate range. That's why I don't think you have the irreconcilable difference that would invalidate the legislature's other statute here, 1242D.
Do you know, obviously the petition history on Ballard was the discretionary petition was refused. I've been unable to pull up the actual petition. We've had some computer issues a couple of years ago that, affected all of the courts. And so we'll probably have to get a paper copy of that. Do you know what the state argued in the petition for discretionary review? Did it make the argument you're making on rehearing now, or?
It did not. So I can't remember if our office did it, but we have a copy of it. So I'll make sure that I can supplement the record with that petition. But I think it's they did not frame the argument as well as it could be because they didn't make the argument, this is about statutory interpretation. The tack that the state made in Ballard was, hey, you have no authority, court, to have this court-made rule about no dual use. And that's not really what was at issue. Like, the court obviously does, like, that's core purpose is statutory interpretation.
And the CCA had already addressed that numerous times since 1990. So
that's right. That's right. So I think the better way to frame this for the court is, yeah, are we, what exactly does the dual use rule mean? And in the 1980s and the 1990s, there's very, very little explanation in the Court of Criminal Appeals decisions about what the basis of that. You have to go back and sort of look at their C sites to know that, hey, they're comparing this to other irreconcilable conflicts. And so that must be the basis of it. That's the other petition for discretionary review that we have in Crenshaw pending right now, has framed that, hey, tell us what is the dual use rule, confirm that it really is a question of statutory interpretation. And I think that will get courts of appeals, we'll be able to see more fully what the analysis is, and then courts can make those calls much cleaner when that's exactly what we're dealing with.
Are there other jurisdictions with habitual offender statutes like ours that that advocate the position that you're taking? Yeah,
and they go even further. So they'll have this sort of same structure where you need 2 felony convictions for habitualized enhancement. And they say there is no conflict at all when one base offense requires a prior felony conviction, because you can give effect to both of those statutes, because the habitualized enhancement requires 2. So you don't have a conflict if you have one felony conviction, and that gives a certain base offense punishment range based upon that one felony conviction. It makes it's not at least absurd for the legislature to say, okay, if you also have another felony conviction, that's going to trigger this other statute, the habitualized felony convictions. Now, I think this court, because of the Court of Criminal Appeals case law for felon in possession, I don't think this court would be able to go that far with the argument, but it's certainly something that the Court of Criminal Appeals could look at if they wanted to undo their decision for felon in possession.
Let's say your theory is correct in theory, in that the availability of other people being treated differently who don't have convictions because they're on deferred adjudication or something. Let's say that is one way to interpret the statute. We still have the fact that this gentleman was actually convicted. So do we get to a different result because the facts are different?
I don't.
In other words, my argument is, or my question really is this not a great argument, wrong time to make it type of position?
I mean, this court could distinguish the situation because he has a deferred, that's the basis upon which he had a lifetime duty to register. And so even though the stipulation and the talk at the trial court level was about the conviction, all that was required was that he had a deferred adjudication. And the parties below could have just agreed to that. That would have sealed the deal for the primary offense and then use of the conviction for purposes of enhancement. So factually, this court could distinguish the situation and not get into a sort of statutory interpretation question. But I think the statutory interpretation question is really the better way to resolve this, that it shouldn't be based upon, let's look at the facts of this particular case to determine whether or not we have a conflict. I mean, that's not the ordinary way of doing statutory interpretation, right? It's usually as a matter of law. Do we intend 1242D to have validity? Or is this a clear statement that this situation and this statute is always going to trump that other statute that the legislature's passed?
Well, and that's what I thought was interesting about McWilliams. The CCA could have taken that route. The court did not do so. It said, well, in this case, they never really addressed the fact that he had been, finally convicted at that point.
I mean, I think factually for escape, that's always going to be those facts. Because you're not going to have a conviction if it's a pretrial detention type situation. So every time that it matters, you're going to have the situation that they had. So maybe that's why 3 of them thought it's worth sort of doing, at least in that application of it. It's hard to know since they didn't explain. But unless there are any other questions, then.
Well, I'm glad you stopped there because I was so excited to get this argument underway. I forgot to start the clock, and I was going to give the appellant an additional 5 minutes. But since we're ending there, then you should start off pretty much where you need to. Thank you. Mr. Wilson.
Thank you, ma'am. Please support. Counsel. The no dual use doctrine and statutory interpretation and all that, I will candidly admit to the court, makes my head hurt in trying to figure out where all of that goes. So where I'm going to start is the part that's easier for me that doesn't make my head hurt, and that's that, as the court started out with, that I don't really know why we're where we're at. We raised our arguments that the state prosecuting attorney has some problems with, but the primary prosecutor in the case conceded error in this case. The court issued an opinion that was consistent with the law as we briefed and as was conceded by the state.
Could we have stopped at that point and disagreed with the state confessing error?
You could have.
And we've done that. We've done that.
You've done that, and you could do that. And I think that to some extent, you have to look, in one case, we didn't cite in our response to their motion for rehearing, but with Rochelle versus State 791 second 121 from 1990, and the date on that may be something that makes it a little stale in regards to where the Court of Criminal Appeals has went since then. But they sort of differentiated between a motion for rehearing and amended briefs and other things that happened during, I guess, what we would call the primary litigation of the appeal, for lack of a better word. And maybe that's a distinction without a difference. I don't know. Rochelle quotes, several of, I don't even know if the numbers are all the same now, but several of the rules of appellate procedure, and kind of goes through why you really shouldn't be bringing up any new arguments in a motion for rehearings. That's not what it's for. It's to correct things. Where I would continue, though, to sort of draw that line is that really, I mean, in her argument today, she sort of is a little more affirmative about it. But when I was reading their motion for rehearing, I was kind of struck by, I didn't understand. I didn't know what they wanted. It was kind of sort of, well, we're not necessarily saying you messed up, but we'd kind of like you to look at it a little differently, maybe go down this road, do that and the other. When what the court did is what we generally want courts to do, which is look at whatever appropriate, relevant, prevailing law or court opinions are out there, which we had in Ballard and Barker, two things that were a little different, but got in the facts, but involved the same issue that's involved here. Both of those cases that is Justice Doss mentioned, we don't know exactly what the issues were on PDR on one of them, but that were denied PDR by the Court of Criminal Appeals. So at least on the face of it, the Court of Criminal Appeals had ample opportunity to address this issue over the course of those years. And to me, what the special prosecutor's office is doing by coming in here is sort of baiting the court to do something different in this opinion, to give them a little more juice to try to get the Court of Criminal Appeals to take this issue. Okay. I'm not necessarily saying there's anything wrong with that from their standpoint. Their particular office has a job they do, and that is something they may want to look at doing, trying to get the Court of Criminal Appeals to take up these issues. But, you know, I don't know that that's this court's job, is to necessarily craft your argument, your rulings, your opinions for that purpose or not. I could see a situation where Court of Appeals might want a question answered, that there's an issue that they believe the Court of Criminal Appeals or the Supreme Court should answer. And they want to very, very clearly define that problem so that maybe that court of last resort would take that up. But the dilemma we have here is that that's been put before the court before. You know, she mentioned maybe one other case that I wasn't aware of that may be on this issue or some issue like it that's before the court. But, you know, I don't have any knowledge or haven't seen anything where, you know, the courts stumbled or made any comments about, you know, wanting somebody to change, to get this issue before them. They've had the opportunity to do it. They haven't addressed it. If they truly believe the rulings, preceding cases that you're following are in error and you're following them, then they could grant PDR on this and they could ask for PDR on this.
Well, let me ask you a question along those lines, because the original draft, like you said just a minute ago, relies on Baker and Ballard. My understanding of my reading of the motion for rehearing was Baker and Ballard are wrongly decided. Can the court, can the state do that in a motion for rehearing?
Well, I guess
I mean, they were the appellee.
Sure.
They were the appellee in the case below. Yes. So
yes.
So what prohibits them from doing that in a motion for rehearing, saying, "Hey, you relied on these cases, but those were wrongly decided"?
Well, I guess they can. They certainly could have in the original reply brief. I think the question, obviously, as I think you phrased earlier, is this argument inconsistent with the position the state took on appeal, which it clearly is. And the question is, can they do it? I posit this question, which I do not know the answer to. It's not probably helpful in that regard, but what if the state prosecuting attorney hadn't come in, but simply the district attorney's office had conceded, and then they file a motion for rehearing? I don't really have a good reason why, but I just seem to think that would be looked at differently. And so in my mind, it's the state. It doesn't matter who's doing it. It's the state. They conceded that issue. They've waived that issue. Now, certainly, if the court picks it up on your own, if you decide it's important enough that you need to address it, you can address it. I don't think anybody can keep you from addressing it. I don't know to what extent, how, prophylactic or rehabilitative, whichever way you look at it, Rochelle is at this point. I don't know whether, if you took their argument and reissued an opinion and we went on PDR to CCA, whether Rochelle would be constructive for them, whether they would think that would control it. I really don't know. And not to be cute or anything about that. I mean, 30 years is a long time. The court has evolved. They do a lot of things they didn't do 30 years ago. And so who knows? But that is sort of one of the standard cases out there on that. And so we think they've waived that. On the actual argument on the merits of it, which I candidly admitted to the court, it gets in a circle to me at some point. The courts of appeals, when analyzing the no dual purpose rule, haven't had a lot of problems, haven't had to go to a lot of gymnastics to get there with it. And some of that, I think, goes into issues of just, they may refer to it, may be a double jeopardy type of argument. I think it's a fundamental fairness type of argument. I understand what the state is saying is that, well, the legislature hasn't come and and said that it's a problem, so it's not a problem. But the flip side is also true. These cases have existed for a long time. The legislature hasn't come in and fixed it either. And I think we all know that anytime we can always say that on both sides, that anytime we're saying, well, the legislature thought about this before they did or didn't do it, that, that may be a concept of law, but that may not be of great practical use to us. So, the court precedents at this point say that your ruling was correct. And the state is coming in, and again, when I read the tone of their motion for rehearing, there's I agree with you that in a sense they're saying they're wrongly decided, but there's a lot of it'd just be nice if you would maybe talk about these issues and say something different about these issues. They ask for you in their prayer to affirm the conviction, but I think that it's asking this court to some degree to do the Court of Criminal Appeals' work for it. You're trying to beg for them to take a case when on what was presented to you in the appeal and based on the law as it existed at the time that you considered the arguments, that the ruling the court made is completely correct, as the district attorney's office said initially in this, that's the state of the law right now. Yes, there are some complications with it into what the statutes say and don't say, and it's been evaluated, it's been analyzed a certain way by other courts of appeals. It's been pretty consistent, and the Court of Criminal Appeals hasn't stepped in and said, no, that's not the way it is. And so we would ask the court to deny their motion for rehearing. Thank you.
Thank you. You'll have 5 minutes. We'll start the clock this time. So answer the question posed. What exactly are you asking us to do by way of rehearing?
Ultimately, I would love someone on this court to, even in a side opinion, say there's some merit to this argument. And even if it's we're going to continue with our original opinion, but maybe this warrants the court looking at. This court, as judges, core duty to statutory interpretation. I feel like this court has some experience that could lend help to the Court of Criminal Appeals. And the opinion as it is hasn't really delved into that question. And so I think the Court of Criminal Appeals, as court of last resort, is looking for guidance from other judges who might consider the issue first. That gives them the ability to look at different arguments, and I think it can advance the law as a whole if this court were to decide to wade into that.
There's been discussion between both sides about what the legislature has not said under certain circumstances and whether we can infer anything from it. So I'm going to ask a related question. Have any of the appellate courts adopted your position on this? Have any of the appellate courts at any point said, we're not going to apply the no dual use rule because the statute under these circumstances is different?
No. As far as I've been able to tell, no one has framed this as a statutory interpretation question. Because I think during the 1980s and 90s, the Court of Criminal Appeals didn't really explain what is the source of the no dual use rule. And so it sort of got taken as this is a court-made doctrine. And then we're trying to decide, well, is this an essential element or not? And I think if it's better analyzed and framed as a statutory interpretation question, that will be better able to distinguish when certain offenses, felony convictions can be used and when they can't.
So in the Crenshaw case out of
Second
yes. Court of Appeals. So did your office weigh in the context of a motion for rehearing before the Court of Appeals, or did you just get involved when it reached the Court of Criminal Appeals?
I filed a motion for hearing in that court, and they promptly denied and sent me on my way. So.
Age is Crenshaw out of the CCA, right?
So yeah, good question. It is currently pending, so they have not decided to grant that issue at all. So PDR has not been granted. I filed it in April, so we're just, waiting. Usually within 6 months, we usually get
But do refer to, this case in your PDR.
That's right.
Urging, that there might be another case coming.
Right. Yes, I feel like this case, we wanted the court to be able to consider the sort of full range. So Crenshaw is pretty narrow. It's like an even further extension than this case because it was not an element at all for that statute. So it's more extreme. So the court may decide, okay, this is where we're going to draw the line in no dual use between these two cases. Or it may decide to draw the line on the other side and say, okay, if there is an essential element by which we mean you have to have the prior conviction in order for this offense to occur. Like, that is the point at which there is a conflict between the general and the statute for the primary offense. Unless there are any other questions, then I'm. Great. Thank you.
Thank you. Well, thank you all for coming and presenting your arguments. You've given us a lot to consider. And we'll take the issue under advisement and let you know. Thank you. Will be recess.
All rise.